Welcome to Notable Approvals. I am attorney Amanda Schaefer. I have another exciting case to talk about today. Before I get to that, quick reminder, don't forget to like us and follow us on Facebook, YouTube, Instagram, wherever you are watching. And if you find this video to be helpful or know someone who may, hit that share button and save button so that you can find this quickly in the future. So we are switching pace from immigration to family court today. Had a pretty big win yesterday at the court. Hadn't been there in person in quite some time. Actually felt nice to be in person. It feels more real, in my opinion. But let's talk about it. So, client who is a Manhattan resident, I believe she's in her late 20s. She's been dealing with crazy ex-boyfriend. Ex-boyfriend who can't accept the relationship is over. I know a lot of you watching out there may say, hey, that sounds familiar to me. Might be an ex-boyfriend, it might be an ex-girlfriend, but sometimes they just won't leave you alone. And in this case, there really were red flags really early on in the relationship. The couple started dating, I believe, 2019, moved in together not too long after. And that's really when she started to notice some problems. There was an incident that had happened back then that she had to call the police where he punched her, threw her head into a wall, and the police came. They they did arrest him. They asked her if she wanted a restraining order. She said no. Now, in this state, it was called a restraining order. In New York State, it's called an order of protection. Same difference. In New York State, it is automatic when someone gets or pretty much automatic when someone's arrested for domestic violence. In this state, it was up to the victim. So, and if you're watching from another state, it does vary state by state. But if you get an order of protection granted by any state, whether it's New York or another, whether they call it a restraining order or an order of protection or something else, sometimes they call it protective orders, it will be enforceable in all 50 states. So you don't have to worry about that. So the police came, they arrested him. Like I said, what ended up happening was I think they ended up dismissing the case. He did maybe some anger management, but she had also filed for a civil restraining order. Now in New York, unless you're going through a divorce, you don't file it in the Supreme Court. You file it in the family court. Now, I wasn't the attorney on the previous case, so I'm not exactly sure, but we just terminology difference. That's all. So he filed a cross complaint against her. They ended up settling. And in general, when you settle with a family offense petition, you're withdrawing it and basically agreeing to leave each other alone. And so that's what they did. That's what they signed, I should say. Did they leave each other alone? No. As unfortunately is the case with abuse, they got back together and they moved back in together. Now, there was other incidents, there's other red flags than this one day where he was physically violent with her. For example, he would throw her things around the apartment and break it. Like she said, she would has mirrors and he would just punch the mirrors. He would call her horrible names, just degrade her family, her friends, her career, just awful stuff. I know because I read a lot of that stuff in the text messages and emails. But they did get back together, moved to New York together. Problems continued. Now, eventually, she decided at the end of 2021, look, I'm done. I'm moving out. I'm done with the relationship. They continue to live together. Now, anyone who is watching out there is a law in New York State that says if you are a victim of domestic violence, you can break your lease. You do not have to give any proof that you are a victim of domestic violence. They can't force you to show a court order, for example. they have to take your word for it, because it's a very private issue. So you would no longer be held responsible or liable for a lease that you signed with your abuser. So you could feel free to leave. Now, this client, I believe, knew that, but I think, you got to find a new place to live. It takes some time. So she really didn't move out for a couple of months. I'm sure that was very uncomfortable. And then when she finally did move out, um, he was throwing her clothes out of the closet, cursing at her, starting to get aggressive towards her and her mom, and she felt unsafe. So she called the police. And again, I'm not positive. There was a lot that happened in this case. So I'm not positive if she was arrested that time. There was a domestic incident report. But when she moved, she did not want him to know where she was. She did not tell him the address, but he was determined to find out where she moved, and he somehow was able to find out. And on top of that, he would not stop bothering her. There was a 3-week time period last year where he called her over 160 times. He sent repeated text messages, emails. There was some Instagram messages. When she wasn't responding, he then started contacting her family and friends and saying horrible things about her. And this is after she said to stop contacting her, which is important for the family case or the family offense case. So she filed another police report because the guy wouldn't leave her alone. And the police, they took the report, but she didn't know where he was. And I don't remember if it was before or after she found out that he knew where she moved that the police started literally canvassing the neighborhood looking for him because they had, a photo of him and everything. But what ended up happening was he had mailed her a package to her new apartment. Really creepy. It was like some old greeting card she had given him. That was it. So it was really, I think, done to instill fear. Like, hey, guess what? I found you. And then he moved to her neighborhood, which not a good idea. So they had to serve. She did file a family fence petition as well then, but they have to serve it on him. Like she did get a temporary protection, but until it's served, it doesn't take effect. However, the police put out an arrest warrant for him. That's why they were looking for him, because he was harassing her, stalking her, amongst other offenses. So a few months later, she's, in her apartment and she sees him. So she has one of those apartments where there's commercial space underneath. A lot of apartments in New York City are like that. And this was a bar. So she sees him at the bar. Now, the bar was the same exact address as her apartment building. So even if he was at the bar across the street, I mean, he's supposed to stay away because by this point, he knew. I think he knew, but he knew to stay away from her, and in the sense that she had told him to stay away. So she called the cops, like, "Hey, look, he's here." The cops came because they had the arrest warrant. That's when that's when he got served with the temporary order of protection as well from family court. They arrested him. She was given a criminal temporary order of protection as well. And eventually, as with these cases tends to happen, well, before I get to what happened in the case, because there's more, a couple of months later, she saw him again. Actually, I think her friends saw him at the same bar under her apartment building. And, obviously she was very shook. She called the cops. The cops came and arrested him for violating the order of protection, because this time it was 100% clear that he had an order of protection against him because he was served with it from the prior arrest. And then she filed a violation petition in the family court. Now, I had spoken to her. I don't remember when I first started speaking with her, but she did not qualify for what's called an 18B attorney, free attorney. Um, and, she's young and she had just switched careers. So she didn't have a ton of money to spend on this, but she wanted legal representation. So we were working with her to manage the cost and then really have her not hire me until she needed. She was a very smart girl. She went to every nonprofit she can find that helped with domestic violence. You're not always going to find an attorney, that can represent you in court, but you might find someone who can help you with things like breaking the lease, finding a new apartment, changing the locks. You can also find someone who might be able to help you draft the family fence petition. In her case, they helped her amend it so that it was sufficient under the law. So they helped her with that. And then, so he gets arrested, and then, we had decided let's let the criminal case play out, because usually the family court likes that to happen, because sometimes what happens is, because you can have an order of protection from criminal and family court at the same time, but some people decide they're going to withdraw their family fence petition in the family court if they get the order of protection in the criminal court, because it does essentially the same thing. You don't need both, but you can certainly get one. So he hired an attorney, and they were going to go to trial. And, this whole time she's just like, I wish he just took the plea for like harassment. And, that's like a slap on the wrist. It's a violation, even though he had the violation of the order of protection as well. In general, that if without a criminal record, that's tends to be what the court does, which is not too bad. I think he also had to go to anger management. So they were pretty much about to have to go to trial, and she's waiting. Finally, he accepts the plea last minute, like right before, they had to start canvassing the jury, pretty much. And so the plea was to a 240, 240-26, 240, I think it was 240-26. The penal code for disorderly conduct and harassment are getting mixed up in my mind right now, but it was definitely harassment. And then she got a final 2-year order of protection from the criminal court. So she calls me and she's like, I'm happy it turned out this way, but first of all, like I'm still really scared that he lives in the neighborhood. I'm still really scared, of him. And considering they broke up at this point, it had been a year and a half since she officially ended it, or over a year and a half, and over a year and a half since she moved out. She was like, I really want a 5-year order of protection, because I had talked to her about how if there are aggravating circumstances and or a violation of the order of protection, the family court can issue a 5-year order of protection. Now, the criminal court could have done that as well. But, and this is one of the things that people take into consideration when they're deciding whether or not they want to pursue action in family court, regardless of whether a person's arrested, is that you don't really have control in the criminal court. You're not the prosecutor. So the prosecutor, especially in these like smaller cases, when I say smaller, I mean less serious offenses. We're not talking about murder cases. We're talking about less serious. And honestly, even in murder cases, this can happen too. Yes, does the victim get a say? In cases where they're minor misdemeanors or violations, usually maybe not. Even in more serious felony cases or more serious misdemeanor cases, the DA can ask you like, hey, what are you looking for? But they don't have to follow your recommendation, because they want a plea. They want the defendant to plea, and a 2-year order of protection is one thing, because they're almost it's almost guaranteed in a situation like this that the DA is not going to issue a plea offer without some order of protection in place. 2 years is the common amount of time. They can issue it up to 5 years, but then the defendant might decide, hey, I'm going to fight this. I don't want this hanging over my head for 5 years. Now, as long as you don't violate it, you're not going to have a problem. But I've said this before. If you haven't seen any of my other videos about orders of protection before, if you ever have one issued against you, even a temporary one, you need to remove all ways to contact that person that is the order is protecting from your phone or your computer. Because if you butt dial them, because this happened to one of our clients a few years ago, you butt dial that person, or AKA call them by accident, you're getting arrested for a violation if they report it to the police, and it's a legitimate violation. So you don't want that number in your phone, especially if their name starts with an A, an AA, like Aaron. He gets a lot of butt dials. So point is, you don't want them in your phone. So we talk about it, and she's like, my mom said, I think her mom helped. I don't know how she got the money. It was either she saved up, or her mom helped her, family member, something. But she still had limited funds, which I totally get, and I felt really bad for her. I mean, it was a really shitty situation. Excuse my French, but accurate. And this guy was nuts. I mean, whenever you see somebody violate an order of protection after being arrested, you're concerned, especially when they've been physically aggressive in the past. So I definitely wanted to help her as much as I can. So what ended up happening was, when the criminal case was over and she told me, like, I don't know, these 2 years, that's going to be enough. That's when she officially hired me. And what I did was I called his attorney and I tried to settle. And, as is usual in these cases, when the other attorney, when the facts are in my favor, my client's favor, the other attorney's like, well, they already have the criminal order protection. I don't know why they need a longer one. He's moved on. He's moved away, blah, blah, blah. And I'm like, well, she's dealt with a lot. He's terrorized her life for the past 4 years. I think it's reasonable what she's asking for. And at first she was really angry, understandably, that now she's going to pay all these legal fees just to keep him away. So she wanted her legal fees paid for too. So he's like, well, he lost his job because of this. We don't know if that's true or not. Okay, well, when did he lose his job? Let me see proof he lost his job, because she gets it. She's not going to spend money for me to write a motion on attorney fees and go and agree not to settle just because of the issue of attorney's fees if he doesn't have the money to pay it. If you ever heard the saying, you can't get blood from a stone, meaning like, if it's not there, it's not there. It's not going to magically appear. So we asked for proof of his unemployment, and then we said we want a 5-year order of protection. And we want him to agree to that. And of course, withdraw the one he filed against her, which I think I mentioned earlier, or it's in the title. He then filed a cross-petition, family offense petition against her. And honestly, it's common. It is very common. In this case, literally his allegations were like, she got me arrested. It's not a family offense. Not only that, yeah, you got arrested because you committed a family offense. And there were a couple of other, and then he said she didn't pay the bills when she left the residence. Well, she moved out. And, I mean, again, not family offenses. It was kind of ridiculous. But I would say, I would estimate 90% of these cases, you see people file cross petitions, maybe a little less, but it's up there. So it's not surprising, even when there's no basis. Almost they'll issue a temporary order of protection for almost anyone. And then, you get them, well, he's worried that she's going to use it to get him arrested again. Honestly, I'm sure that things like that happen, but in my experience, at least, clients are just grateful to have some sense of security. They don't want to call the police. They don't want to deal with this. They don't want to pay attorney fees. They don't want to aggravate the person. So that's kind of a nonsense excuse. So his client did not want the 5-year order of protection. And then I tried to negotiate a little. I was like, look, why don't we, instead of no, what normally happens unless you agree is if you win and you get the order of protection, it starts, even though you've had this temporary one, the whole, however long it's been pending, it starts the day you win the trial. And then it goes, for whatever time period it states on there. So I was like, well, why don't we agree to backdate it? So it's technically a 4-year order of protection or a 3.5-year order of protection. And he still was like, not sure he's going to try to convince his client. And I was like, well, look, if you want me to try to convince my client to lower the time that she wants an order of protection for and not seek attorney fees, because he did violate the order of protection. It's a clear violation. He was at her apartment building. The police came and arrested her. There's absolutely no question after he was served with orders of protection. It's like, if you want that, I need proof that he has moved out of New York City, or at least out of her neighborhood, so she doesn't have to worry about running into him, and that he's unemployed, because this is messed up. He should pay her legal fees after all he's done to her. So we waited. They sent me some documents. It was like 1 page of a tax return showing some unemployment compensation that was clearly did not cover a full year or whatever, even the 6 months that they give you. And this guy had a good job, some type of something in finance, at least at the time. And so I wrote back and I was like, well, thank you, but this doesn't actually show that he moved, and this doesn't actually show he's not employed now, and that he's been unemployed this whole time. So like we would like additional documentation. Now this was like over the summer I was asking for this, and we hear nothing. And she's checking in with me like every few weeks. Have you heard from his attorney? I'm like, no. Have you heard from his attorney? No. We keep calling him, emailing him. Finally, a month and a half ago, get a call from his law partner, who does not do this type of law. It does something completely different, telling us that his attorney was very sick and it looked like he was done practicing law for life. I believe he was an older gentleman. It's like, oh, that's horrible. Like, what, we were trying to get these documents from the client so that we can settle, because if we settle, again, that keeps the attorney fees down, because then I don't have to prepare for trial. I don't have to go to trial. So he was like, all right, I'll get back. So at first he called, I was in court. I call him back. Voicemail not set up, or voicemail full. Email him, nothing. It wasn't until I think last week he finally returned my call. And he's like, I don't know who this client is. I don't know him at all. I don't know anything about the case. I was like, wait, going to appear? Because what's going to happen? We need to know. And it was an in-person appearance. And he's like, I'm not appearing. I was like, okay. He's like, I'm going to tell him he needs to get a new attorney. He's like, I don't even know how to contact him. I was like, all right. Now, if you're wondering what this guy's obligation was, or duty under the law, because his law partner could no longer practice, like, could be a similar situation if someone suddenly passes away. I haven't researched all the ethics. I do believe he should have at least told the court. I do believe he could face some problems, but look, he was incredibly stressed, which I totally get. I don't know how many cases they had in their firm. I think it was just the 2 attorneys, but now every single case that this other attorney had, he's having to call people and figure out who the clients are, who the attorneys are. I mean, it's honestly a nightmare, and I really do feel for him and for obviously the attorney who's sick. Like, that just sucks. But it ended up helping us just because it made the trial easier, and I'll explain why. But it's not a situation you ever want to be in as a partner in a law firm. You don't wish that upon anyone, of course. I was really sad. I was really, disheartened to hear that. And then we also had a big question mark over the case. Like, are you going to is this um the opposing party going to show up and now say I need a new attorney and drag this thing out even longer? Like, I will tell you, this is my immigration clients. You guys definitely wait a long time, and patience is a virtue, and it sometimes can be hard, but these family court cases feel like they drag on so much longer, even when for me, I'm like, that's a normal amount of time, but, like, people just wanna get it over, they wanna move on with their life. Um, which I totally respect and understand, and I was like, "Look, I don't know. If he asks for another attorney, he's gonna we're gonna get another court date. Like, that's it." I can at that point, I wasn't even allowed to call or contact this guy because he was represented by counsel. So, I wasn't even allowed to contact him until there was, um, a motion to withdraw his counsel granted by his former attorney or former partner of his attorney. That didn't happen. So I couldn't try to settle it directly with him. You're not allowed to contact a opposing party when they're represented. So I was like, if he comes to court and says he's going to represent himself, I can try to negotiate. I was like, but honestly, I hope he doesn't, because that will make for an interesting cross examination. Because that's what attorneys do. We do trial, testimony, direct. We do a direct. We do a cross. We introduce evidence. I was like, honestly, I've never had a trial for one of these where both where the opposing party represented him or herself and was allowed to do a cross examination, because I've never had it where they've represented themselves. So I wasn't even sure, and I've been so busy last month, I didn't even try to look. I was going to object to it, of course, because it's to have your we could even say alleged abuser uh, do a cross examination is doesn't make any sense, because that in itself can be incredibly traumatizing. So, and I told her, I'm like, for a direct exam, it would be a speech. So that he would basically be giving a speech. So basically, we had no idea. Was he going to show up? Was the judge going to was he going to ask for more time to get a new attorney? And then the other question if this other attorney had contacted the court, even though they're supposed to like include me on anything, I may not have known. They may have just sent a letter to the court without telling me, and the judge knew what had happened. The judge may have given him more time, but I will say this, because I always try to do what's fair and just under the law. I want my clients to get what they want as quickly as I possibly can. I also don't want things getting appealed and overturned, and now you're back. And if there was a situation where I had to tell the judge something that maybe my client didn't want me to tell, but I knew it was in their best interest because it could be appealable, then I would have done what I had to do. But the hearing prior to this, it was my first hearing appearing in court. The attorney appeared, but the client didn't. So the judge could have ordered it, issued an order on default at that point, but we weren't ready to go forward because I just appeared. I just got the case, but not even that. They usually give one more chance. So this was his one more chance. So we get to court, and not surprisingly, no attorney appears. He doesn't appear. That was not the end of it, because if it was, I maybe wouldn't have talked about this case, or it would have just been like, yay, default. You still have to prove your case. So you have to prove by preponderance of the evidence, which means like 51% or more, that likely that this person that you're claiming committed these family offenses against you actually did. And then for the violation, you have to prove by clear and convincing evidence, which is more than a preponderance, not beyond a reasonable doubt. So if you're going to put a percentage, maybe around 75%, that show that the violation was committed. So I had to, you know, I had to go through the testimony with her. Now, the judge had ended up having to schedule another case. We had, I think, a 2-hour slot, and now it's an hour and a half. We were taken late, and all I knew is, for my client's sake, I don't need to ask her every single question. It's a litigation strategy. You have to decide. I was like, but I need to get this case done within this hour so that she can be done with this. And that's what I did. I asked her, I set forth the facts to prove that the family offense was committed. All our evidence was admitted without objection because no one was there to object. And there was definitely some things that could have been objected to, like text messages without dates. Another time I can explain how to properly present electronic evidence like text messages or videos or any type of audio, but not now. I'm already been talking too long. And so we proved her case, and then I did a little closing for the judge. I told the judge what we wanted. We wanted the 5-year order of protection. We wanted him to be found in violation, and we wanted him to pay for her attorney fees. Now, one thing I didn't mention earlier was at the beginning of the trial, the other day, the judge said, "Are you looking for a contempt finding?" as opposed to just a violation. So that's a contempt of court. Why does it matter? It matters because that is what can subject someone to incarceration in family court. It can only be up to 6 months, but the judge can order them to go to jail. However, we had a court attorney referee, which is very common in family court, instead of a full judge. You still call them Your Honor, you show them just as much respect, but they don't have the full powers a judge does. So if we were seeking a contempt finding, rather than go through a trial twice, the judge was like, "Look, if that's what you want, that's fine, but I can't hear it. I'm going to have to give this to a judge." So, I asked my client, and if you're wondering, well, is that double jeopardy because he had the criminal case and it was based on the same stuff, and they gave him his sentence, and in his case, he didn't get any jail time. The answer is no, it's not double jeopardy. It's a different standard in family court. It's a lower standard. It's easier. You don't have to prove it beyond a reasonable doubt. It is clear and convincing evidence. But it's just a different thing altogether. So yes, they very, very well could have ordered him to go to jail for any period of time. We didn't know where he was though. So finding him and executing the arrest warrant at that point would have been difficult. But either way, I said to my client, there's a small possibility, because it was an afternoon case, that there's a judge that's able to hear it today. But in all likelihood, we're going to have to come back. And if we come back, I don't know how long it's going to be. And she was like, no, she's like, I don't want him to go to jail. That's not my goal. I just want this 5-year order of protection, the order for attorney's fees, blah, blah, blah. So, after all that, I explained, and the judge found that the family offenses committed were harassment, aggravated harassment, stalking, criminal mischief, and disorderly conduct. And he found there were both aggravating circumstances because of how bad the harassment was and the fact that he stalked her and followed her to move to her neighborhood, and found there was a violation, which triggered the provision of law that says attorney fees are automatic. So it's not up to the judge's discretion. The judge does have discretion to award attorney's fees for the part of the case that was the underlying family offense petition, which he found. But one thing that was really nice is I did not have to waste time writing. I told her, I was like, we might have to come back just because of the attorney fees, because they make you file a motion and prove that your fees are reasonable and that you have the proper experience. This judge happened to know me, which is less rare when you're an attorney in New York City and there are so many, and you don't just practice in one borough. So I do get repeat judges, but this one I actually had not too long ago, almost an identical case, to be honest, and got almost the identical outcome. Actually, I think the identical outcome. So he ordered the 5-year final order of protection starting from the date of the decision, the other day, and he said the amount of attorney fees I was asking for was reasonable, so he ordered that, and he also dismissed the other petition since the other party did not appear on his own petition, so that was what was expected. So that was a lot. Um, I like to really go into details about these cases because I feel like a lot of people don't really know what they are, especially why you would possibly want to pay an attorney to represent you in family court when there was already a criminal case and taking care of the situation. Like I said, there's differences, and that they're important differences. And that's why you should talk to an attorney and make that decision. I had, we always understand people's financial situation here, and we try to work with people. And I told her, I'm like, you can't just hire me for one appearance because that might not be the only appearance. Like, you can't just ask. I've had people a lot of times call and want to hire me just for the trial. Happy to represent you at trial, but it might not be done that day. There might be something else that happens, and then I'm your attorney. So, you definitely, what we ended up deciding was, let's wait for the criminal case to be over. And then if you still want to proceed, we'll go about it. So we kept her costs down, and hopefully he pays. I mean, I've won a lot of judgments for attorney fees. I don't know if I've ever gotten paid from that person on the attorney fees. It's never my client, it's the other party. So he has to get the order. They're going to send it to him. Hopefully he gets it and pays it. But regardless, the case is over. Client was thrilled. Mom was in tears because these things really take a toll on people. Even people now do understand abuse in a very different way. That it doesn't. You don't need physical abuse to be traumatized and to be in complete fear. And you should not have to wait for physical abuse to occur for that to happen. So they were just really relieved that it was all done. And now she can move on with her life. And I know she's still in the apartment that he knows. So she's hoping to, or no, she moved. Yeah, she moved already. Address confidentiality program. I didn't even know what her address was because it's confidential and all. I mean, I know it, but I knew at least I didn't need to have it updated for it. But yeah, always tell your attorney when you move. But she was on the address confidentiality program, which is really helpful. Most states have it. I know I can't speak for every state. New York 100% has it. But when you don't want someone to know where you live because of some type of abusive situation, you apply to it's not even really an application. It's not really applying. You're just kind of submitting an application. I've never heard anyone get turned down, but it keeps your address confidential. And it also ensures that if someone does need to serve you with documents, that they can. It does not necessarily keep your address confidential from every possible way there is to get it, but it can't be on court documents, because I do know other clients who've had problems keeping their address confidential if they bought a home. In her case, she already had it confidential when she moved. This guy had found out. I don't even know how I don't even remember how he found out, but he found out. So, you still have to be careful. There is a way to remove it from public databases. Again, I don't even know exactly, but apply to the address confidentiality program in that situation. So that is all for today. I know I talk a lot more when I don't do these as often. I like the new mic. It's a lot of fun. A lot of fun to talk into mics. Don't forget to Like us and follow us on Facebook, YouTube, and Instagram. We're gonna have a lot of new content coming out end of this year, early next year. Take look out for that. And for those of you who do not want to watch all 40 minutes, we're gonna cut these videos up for you as well, so that you know you can kind of narrow in on what you want to watch. Although I recommend watching it all. If you found this video to be helpful, or know someone who may, go ahead and click that share button. If you or anyone you know is currently in an abusive relationship, you do not have to stay in that relationship. You have a right to be free from abuse. Our contact information on YouTube and Facebook, scrolling across the bottom of the screen. And Instagram, go to our bio page and you will find it there. We're more than happy to help you. Um, these cases have some hard facts, but it is really important work to make sure that people can get some protection and peace of mind, because you have that piece of paper, that person comes near you like this guy did, boom, arrested. So although it is a piece of paper, I do like to mention that as well. And so, feel free to contact us. There's also plenty of domestic violence organizations out there that provide help to victims. I will post in the comment section tomorrow, probably, some of these organizations. I've posted it before, which you, again, if you look at some of our older videos, you search for domestic violence hashtag in our pages, you can probably find that information there, or check back tomorrow. And that is all for today. Thank you guys for watching, and I'll be back soon with a new case. And you'll also be seeing Attorney Shapiro soon. He has some interesting cases to talk about as well. Have a good day.